Hello and welcome to the Arbitration Conversation. So in this webisode, we're going to talk to a leader and expert in Australian arbitration. Joe Delaney works at Baker McKenzie, where she is a partner. She's a partner in the firm and she focuses on arbitration in commercial, in construction, and in investment arbitration. She has arbitrated under the ICC, the LCIA, the SIAC, the HKIAC, the AAA, UNCITRAL, and ICSID arbitration rules. She has great experience with a lot of different rosters, really impressive. It's like alphabet soup, all the different groups. One of the members of the ICC Court of Arbitration in Australia, and is also a member of the ICICA Practices and Procedures Board, as well as CIR Practice and Standards Committee, ILA Management Committee, and the Pledge Steering Committee. So very heavily involved in arbitration in Australia and throughout the world. Joel, thank you so much for taking the time with us today.
Thanks, Amy. It's great to be here. Thanks for the opportunity to talk with you about arbitration in Australia.
Well, I'm excited to hear. I guess I wanted to start with a little bit about your journey to arbitration. Before we began, we were talking a little bit about it, and I think it's a really great story of how one becomes an expert in arbitration and ends up working in this area.
So my interest when I was at university was to work in international law, and I wasn't quite sure how to do that because I decided I wanted to be a lawyer. I wanted to work on cases. I didn't want to work in policy. I enjoyed writing articles and teaching, but I didn't want to be a full-time academic. So I thought I want to work in a law firm on cases, but I wasn't quite sure how to do it. And then I came across arbitration, and it still had the international element with cross-border disputes. And it also potentially had the investment arbitration element, which at the time was not a big deal. So I joined an arbitration team in London. I was very fortunate to join them. It was one of the first arbitration teams in a large global law firm. And within my first 6 months, I started working on a commercial case, a construction case, and my first investment treaty case. And when I got the investment treaty case, I was like, wow, this is it. This is what I want to work on.
That is very interesting. And then in Australia, then you end up there and you have continued with arbitration.
That's right. So when I was thinking to return to Australia, I was in London for more than a decade. And we decided as a family, it might be time to move to Australia. My parents were getting older. It's a good lifestyle. And also Asia seemed to be a more exciting place than Europe at the time. And this was soon after the GFC, as we call it in Australia. And also there were had been recessions in England and in Europe. So we moved back to Australia, and the partners I spoke to at Baker's were very much warning me that I may not get to do much arbitration work. There'll be a lot of commercial disputes work, but it'll go to court. And as it turns out, most of my work is arbitration and pretty much has been for the last 7 years. So I'm very pleased about that.
Do you think there's a trend toward more arbitration in Australia than there had been before?
There certainly is a trend. So I've seen more and more arbitration clauses going into the contracts. And now we're seeing more and more of those contracts going into dispute processes. And so I see in my practice a lot of construction disputes going to arbitration, but also commercial disputes. And many of my colleagues in the disputes team are also working on disputes, which if they go anywhere, will go to arbitration. Sometimes we find that the parties have agreed an arbitration clause, but then at the end of the day, they decide to go to court and no one challenges it. But we are certainly seeing a growth in arbitration. I think that's only going to increase, particularly with cross-border transactions.
That's really interesting. You know, we had kind of a growth spurt of arbitration, I would say, starting about 20 years ago. But construction arbitration, I actually used to practice in that as well, and that's something that's been around a long time. Is that true in Australia as well, that construction is an area that's been traditionally where disputes are resolved through arbitration?
Certainly construction has been an area for domestic disputes, domestic arbitrations and international ones. So typically there were a lot of domestic arbitrations, and two Australian parties would be referring their matter to arbitration. But the arbitrations were, and still are, those types of arbitrations are often just run like court proceedings. So we're actually seeing that within domestic arbitrations, the more sophisticated players in the construction industry are increasingly saying, depending on where their project is, that if they were to go to dispute, they would prefer to go to court, but only in some states, because those courts have improved their case management processes. And so they will manage the case better and they'll push it through in a faster, more efficient way. And if the domestic arbitration is being run like court, then there's not much benefit of going to arbitration. What we're also trying to work out in Australia, though, as we see more and more of our arbitration lawyers coming back who have worked overseas and now coming back to Australia, is to try and improve the processes in Australia so that our arbitrations are run in a way that's more consistent with international standards. And that's something that is improving, but we do have a lot of work to do on that front.
Well, that's really interesting. I mean, I'm also curious though about arbitration clauses. So I would love your take on sort of in Australia, sort of enforcement of arbitration clauses, as well as drafting issues.
So it's interesting, in Australia, we've had quite a few court cases in the last few years on how to interpret an arbitration clause. And it's a little bit unfortunate that this issue hasn't fully been resolved by the courts. So the Australian courts will tend to focus on the arbitration clause just being another provision in the agreement. So they start with the starting point is that the arbitration clause is to be interpreted like any other clause in the contract. Now, I don't disagree with that approach, but the point they've not addressed is the level of review required. So often the courts are looking at an arbitration clause in the context of a stay of court proceedings so that the parties can go to arbitration. And as we know, in many UNCITRAL jurisdictions, the courts have adopted a prima facie approach. So they just take a very high level view of the arbitration clause, and as long as it looks like an arbitration clause on a prima facie basis, then it should be referred to arbitration. The arbitral tribunal will decide its jurisdiction. If there's an issue, it can come back to court. So that should be the approach that should be adopted, I think, that's, to be consistent at least with the UNCITRAL model law. In Australia, they've not formally adopted that approach. There's no definitive statement that that's the approach to be adopted. So sometimes we see the courts adopt different approaches. So the other approach, of course, is the balance of probabilities approach, where the courts will take a more detailed analysis of the merits of the case and the clause to determine whether the particular dispute comes within the arbitration clause. And sometimes the courts will take 4 to 6 or even 9 months to make that decision, which defeats the purpose of the stay application. The stay application is meant to be really quick and short, so you get your decision in a matter of days or weeks, not 6 months, 9 months later. So it's really unfortunate that we've not had a definitive statement on this. Last year, there was a very high profile case that had come through the federal court system. So first instance federal court, they decided balance of probabilities. The full court said, well, we prefer the prima facie approach, but we're going to focus on what the contract says. And then it went to the high court, and all they said was, it's a contract clause, you interpret it just like any other contract clause. And they didn't say anything about prima facie, balance of probabilities, or the presumptive approach that's been adopted in England with the Fiona Trust case. So that was a little bit disappointing. And now we don't have a definitive position, and you have to argue it out in each case, in each court. With the federal court system, we have the federal courts doing cases across Australia, but we also have state courts, and they can all take a different approach. The only thing that we are consistent on is that they will interpret the clause with the commercial objectives. They realize it's a commercial approach has to be taken, and it's preferable to have the disputes heard in one forum, not multiple forums. But beyond that, there's no definitive answer, unfortunately.
Well, you must end up with a lot of forum shopping then, I'm picturing. I mean, I would think as a lawyer, then sometimes you're thinking about which forum, which court you want to go to, because different courts are having different approaches toward the enforcement.
Yeah, potentially as an arbitration lawyer, I would encourage any arbitration question generally to go to the federal court, because they have the most experience and particularly in some jurisdictions. Some state courts have quite a bit of experience now, and they are giving good decisions. It just depends on which one.
Yeah, but that's really interesting because, yeah, I mean, I definitely, if you're looking at sort of the prima facie approach, you're trying to focus on more, have expediency, right, and efficiency. But yeah, if you're having a lot of litigation about arbitration, then it sort of hinders that efficiency. Interesting. Wow. Are there any other emerging issues that that you've seen in Australia currently?
Well, one of the other issues is obviously, and this is connected, is drafting a dispute resolution clause carefully. So this was an issue I saw in England 20 years ago, and there are still issues there, but not as many as I still see in Australia. And we're seeing it come out in the cases now because parties have not drafted their clause carefully, so they end up in dispute in the court about the clause, which is a waste of time and money, obviously. One of the major problems is it's very common to have multi-tiered dispute resolution clauses, and I think that's the same world over. And they're often not drafted to allow the parties to move through the process. That's one issue. But the second issue is the carve-outs that they try to put in the clause so that different disputes go to different processes. So we saw a case last year where the carve-out was that certain disputes would go to expert determination and other disputes would go to arbitration. The parties were actually moving on the path of going to arbitration, but before they sort of agreed on everything, the limitation period was about to expire, so the claimant had to commence proceedings. They commenced court proceedings and at the same time applied for a stay, but they did that just to mark out the limitation period. The other party, the counterparty, then said, well, hang on a second, the clause says that this type of dispute should be going to expert determination. And so then they argued that with the court, and the court agreed with them and said it should go to expert determination. So that's one problem. But there's another problem too, which is similar. We saw in a very recent decision in the Court of Appeal in New South Wales, where they had a very specific clause about what type of disputes go to arbitration. And it said something like, if the dispute concerns any monetary amount payable and or owed by either party to the other under this agreement, then it goes to arbitration. And the courts took a very legalistic approach to that clause. If I read that clause, I would think that any claim for damages for breach of contract goes to arbitration. And that was the view the president of the Court of Appeal took, but not the majority. The majority drew a distinction between a claim for money under the contract, so like a claim for payment. There was no claim for damages under the contract, no entitlement to damages expressly under the contract. The claim for damages was a claim in general law pursuant to a breach of the contract. And that is not a claim under the contract. So they didn't refer it to arbitration. So these semantic or legalistic distinctions have come up before in Australia. We tend to overcompensate by having all of the connecting phrases in our clauses arising out of, relating to, in connection with, just to cover everything and make sure it says all disputes go to, rather than trying to carve them out as well, just so that we avoid this legalistic approach. I find it difficult to understand this distinction that the judges have drawn. I'm not sure that the commercial parties intended such a distinction to be drawn.
Oh, and in fact, it's funny because when I teach arbitration, we have some cases here as well where courts have been really like a surgeon about the words that are used in the particular contract. And I always laugh because most likely no one ever read that clause when they were putting the deal together. And they have no idea but the intent was probably that any and all issues that would arise or have anything to do with the contract would actually be arbitrated, because otherwise, why would you want to be in two venues at once?
Exactly.
Yeah. That's interesting. Wow. Yeah, those are good cases, though, to really kind of, as a contracts person, to kind of think about and the way you draft it. Well, so when you draft your own, do you go for just the broad clauses that include all the different language, or do you have a kind of a set, easy phrase that's a little bit simpler than maybe the arising under, or, kind of the long clause, or do you have a shorter version that you're able to use in your own contracts?
We tend to stick with a little bit of a longer version, so arising out of, relating to, or in connection with, but all disputes. So if I see a contract and in draft state with a split between technical disputes and non-technical disputes, I will raise that with the parties and say, do you know what you're talking about as a technical dispute? If you're to refer that to expert determination. And if you can you identify the specific provisions in the contract that are to go to expert determination? Or, you know, if it's a dispute about specifications, let that go to expert determination, but be more specific. Don't just say technical disputes. So that's one thing I always pick up on. The other thing, I mean, my personal preference is if you're doing a dispute resolution clause, and unless you want something like expert determination, just include arbitration or litigation. You don't need all of the other ADR mechanisms because firstly, the parties will negotiate. If the parties are talking to each other, they will negotiate. So you don't need that in your clause. The problem with it is if the parties are not negotiating, it's a condition precedent. You've got to comply with it very strictly. And if you don't, then the other side can claim that your dispute does not have standing yet because you've not gone through conditions precedent. So the tribunal doesn't have jurisdiction or the court doesn't have jurisdiction. Then you can go to mediation, but the parties will tend to agree mediation if they're talking. If they're not talking, then mediation's a waste of time. And in Australia, nearly every dispute goes through mediation anyway. The courts will force us to mediation, and we tend to go before the courts force us, but that's because the courts will force us. So mediation is very common anyway. So then my preference is just stick with your arbitration clause with nothing else around it. And just if you want to negotiate, you negotiate. If you want to mediate, you agree to mediate, but you don't need it in your clause.
Yeah, no, I think that makes a lot of sense. I mean, there's so much litigation about sort of that duty to mediate in general, because what does that even mean, right? You know, you can just show up at the some building and then everybody leaves, you know, I mean, if you're not going to talk. Wow, that's really great. Well, I have to say, this has been a lot of really, really great information, a lot to chew on, a lot to think about. So I really appreciate your taking the time. I know I learned a lot about Australian arbitration law. So Joe, thank you so much.
Well, thank you, Amy, for the opportunity. It was a real pleasure to speak with you.
Oh, super fun. Have a great day.
You too.